Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In the classes, friends, I have already told you that there are separate tribunals headed by judicial person, supported by members who are experts in the particular field. Suppose if APAT, Andhra Pradesh Administrative Tribunal is there. Yes, definitely the judiciary will be head, but the members, retired IAS or IPS officers will be there, so that they will be knowing the difficulties of the employees, administrative matters. So what is the charge memo, what is the censure, what is meant by PPA without future increment, without effect on future increments, like that, they know. So for that purpose only the tribunals were established. The purpose of establishing the tribunals is to lessen the work of the court, at the same time to see that the decision is taken by the members who are experts in the particular fields. So friends, tribunal is equal to high court, but please remember, if at all any appeal has to be made by the orders of a tribunal, you have to go to the high court. This is a typical problem. So we have been laughing at this, but anyway, high court is definitely, it is vested with so many powers. Therefore, orders of the tribunal are subject to the appeal in the high court. This much everybody knows. So knowing this also, if the tribunal gives different orders other than high court's order, then what to do? Don't do that. That is what is held by the Honorable Supreme Court of India while deciding the case of State of Andhra Pradesh versus Kanumuri, Raghu, Krishna, Raju. So we all know, every day he comes on the TV. So Triple R we call him, right? Anyway, in civil appeal numbers 4522 or 24524 by 2022, and the judgment has come on 1/6/2022, and you can see the citation in Live Law 2022, SEC page number 544, right? So two judges bench, Honorable Bhushan Ramakrishna Gawai and Hima Kohli, they held that National Green Tribunal is subordinate to the High Court, and if they pass anomalous anomalous orders, then the authorities would be in a jeopardy. The authorities, definitely the government authorities, would face difficulty as which order they have to implement, as to which order they have to follow, is it not? Suppose NGT says stop it. If the High Court says continue it, whose orders we have to follow? This is the main problem. So here these tribunals should remember that they are, even though literally they are equal, but they are subjected to the appellate jurisdiction of the High Court, right? Now the matter, it relates to Andhra Pradesh, Rishikonda. So daily you have been seeing in the newspapers, it has been coming that the Harita restaurant in Rishikonda, it has been demolished. Of course, the government says for beautification or some amendments or additional facilities, to give some additional fees, we are demolishing the same, right? So actually, the state of AP is running a resort in Rishikonda of Visakhapatnam. Very beautiful place. So when I was working as DSP Marine, quite opposite it, my office was located. Very beautiful location, right? It was demolished for reconstructing with the additional facilities. So in this connection, somebody filed a writ petition before the High Court. Of course, High Court passed interim orders permitting the construction because government has expressed and exposed that they want to beautify the area. In the meanwhile, the MP, the Mr. Kanumuri Ramakrishna Raju, he wrote a letter to the National Green Tribunal, and therefore, basing on his letter, NGT prohibited the state from undertaking any further constructions. Now, what to do? This is the main problem. See, somebody has filed a writ petition before the High Court. High Court said, go on, continue. But this man, Ramakrishna Raju, he sent a letter to the National Green Tribunal which restricted or which asked the state to stop the further constructions. So agreed by the orders of the NGT, State of AP, it went an appeal to the Honorable Supreme Court of India, challenging the proceedings of National Green Tribunal. As High Court was already in actually seizing of the matter, in seizure of the matter. High Court knows the matter. So please remember, Supreme Court said that. In any case, no law is necessary to state that tribunals are subordinate to the High Court. So they have to mind that tribunals are subordinate to the High Court, right? So the reliance was placed on the famous case of L. Chandrakumar versus Union of India also. Right now, the orders given by the NGT, they have been quashed by the Honorable Supreme Court of India, and now the matter is left to the High Court. High Court will decide whether to continue the construction or to stop the same, basing on the letter sent by Kanumuri, Rama, Krishna, Raju. No doubt, High Court or Supreme Court has taken a wise decision because it is an administrative decision of the government. If they do not do as promised in the affidavit, definitely they will be taken to task. No doubt, politically they may be telling so many things, but on paper, if they put it, they have to abide by it, is it not? So, good decision by the Honorable Supreme Court of India. To conclude, I want to tell you, please remember that even though tribunal is equal to High Court, but appeal should lie to the High Court only, not to the others. There's an important point. Even in judicial questions, judicial officers preparatory test also, this type of question is being put. I have seen one question like that. So please read the case law and enrich your legal knowledge. Thank you very much.